the majority of lakes weekly throughout the season. And as you probably know, a handful of the lakes last year, and primarily in the outer reaches of the watershed, actually had high water levels and actually above ordinary high. Most of the lakes currently within the Lake Improvement District are still quite low. There was a little bump last year, they went up a little bit, but they're still quite low. And I don't expect much from snowmelt runoff this year. Watercraft inspections, we do inspections at all the boat, last year we did inspections at all the boat launches last year. And as we talked last board meeting, we're going to gear up the program quite a bit more this year and do a county-wide inspection program. And again, last year and this coming year, we're working with the Comfort Lake Forest Lake Watershed District to provide inspections also at the Forest Lake accesses in those areas. Last year we logged in over 3,000 inspection hours, and that'll likely at least double this year. Again, it was like 3, 4, 5 years ago, after we established the LID watershed boundary map, the areas, there's 5 area directors and 2 at large. The areas of the directors were also expanded to fit the entire watershed area. So they like Area 1 director represents everything in this watershed, Area 5 everything here. Okay. For your consideration.
Maybe as a segue, Jerry, we're going to have a few slides that segue into tab number 14 in your packet, which is an action item before you. Back in December, the Chisago Lakes Lake Improvement District Board had recommended that we bring forward a recommendation that the Lake Improvement District taxation boundary be adjusted to match the watershed boundary. And so that's why you've seen some distinctive language here from Jerry, the difference between the taxation, the LID taxation boundary and the watershed boundary. And so he's going to segue into a little bit of process as to how, if you choose, you would proceed to do that. And then the RBA in tab number 14 summarizes some of the numbers and a little bit of the history, and concludes with the recommendation that should you choose, we would recommend that you move to prepare a resolution of intent in which we would outline in detail the process and the stages you would go through if you choose to pursue and begin the process of adjusting those boundaries. Sorry, Jerry, to interrupt you.
You're welcome. So, if we were to start the process, according to state statutes, to expand the boundaries of Lake Improvement District is the same process it would take to start a lake improvement from scratch. It's not just expanding the boundaries, it's everything. Kind of one way I think of it is, okay, and this is my understanding. We have the current Lake Improvement District represented here. That's in place, that's here. If we were to work on a new one, that's over here, brand new one, if this new one passes, it would replace the old one. If this new one doesn't pass, the old one's still there. It doesn't go away. So that would be, so if you were to approve it, we start the process as if it's brand new. And there's 3 ways you can do that. One is initiation and establishment by the county board. That's what we're suggesting. Another way to do it would be to initiate if the landowner's petition to have it take place. And the third way is a creation by the Commissioner of the Department of Natural Resources. So those are the 3 ways. And within that, there's a number of statutes and rules that dictate the process that we go through. Okay. Oh, and back on process, if you did approve it, we provide first off the resolution of intent saying this is our intention of going ahead with this. And that the process would include public engagement, public hearings, public notice. You know, it would be a substantial process.
I have a question. Have any landowners asked for this, requested this, or petitioned for this?
No. No.
The recommendations or analysis up to this point has been through the Chisago Lakes Lake Improvement District Board. So they've talked about it at several meetings, and but we haven't had a public hearing or solicited public comment on it at this point.
So at this stage, it's the LID board to make it broader, make it bigger.
Correct.
Okay, thank
And these are just some examples of what ifs, if we did go down the road and what if. The current lid taxation levy is $232,000. Currently, there's 5,600 parcels within the Lake Improvement District. This isn't actual persons, it's parcels, 5,600 parcels. On average, each parcel pays $41 a year for the Lake Improvement District. If it was expanded to the watershed, there would be an additional 1,370 parcels added, total of 7,033. The average levy per property would be $33 rather than $41 average. The people currently in the taxation area would see an $8 average decrease. The ones not currently in the taxation area would see a $33 increase. This is what's recommended by the lid board. They're not recommending an overall increase in the lid budget. They're just recommending that more equalization. So.
Much of that recommendation, I think, stems from the 2009 process that they started working on a watershed basis. Things like the targeted watershed grant that the Soil and Water District received, the $900,000 grant, that's supported by the lid. And so they really focused on watershed work, and it's been a number of years, and so that's why they made that logical progression to at least recommend that they now look at the boundary as a watershed as well.
Another possible scenario, and again, this is not recommended by the lid board, but if you were to keep the average levy the same, the average levy right now currently is $41. If you keep it the same, have it for the entire watershed, there would be an increase in the total annual levy, $41 increase for people not currently in the watershed, no change for the ones there, if you choose. And another example is if you were to go ahead, do it over time, just have a phased-in increase. So, but these are all decisions you would make if you decide to go ahead, and if we get to that point, then this would be part of the decision making. So.
That's a good segue, Jerry, and maybe, rather than go through the request for board action that I have, I'll just summarize for you that as a request of the Lake Improvement District, as well as presented to you by the staff, if you would like to move forward with an evaluation of the Lake Improvement District boundary, we would recommend, and we prepared the motion, that you have us prepare a resolution of intent, and that we outline that process and present that resolution to you at an upcoming meeting.
Mr. Chair, I'm going to recommend the staff's recommendation here that we start the process, and that's all we're doing tonight, is starting the process, and everything will come back to us in the water board. Is that right? Makes sense. I mean, everything we're doing is within the boundaries of the watershed district, and yet we're just inside the lid district, so it just makes sense that we go to the watershed itself, which is, and as you said, Jerry, the quality of the lakes are getting better, and the practices that we're doing seem to be working, so it just makes sense that we look into it and see what we have to do to expand the district. So I'll move approval.
Second.
Second.
Right. I'll discuss it. This doesn't affect my area or anything at all. It's based. It looks like most of it's in your area, George. The larger portion. It's in yours. So, see, to me, it's easy to vote on this. Agree on this one. So that's why I was just asking if some of the other ones that are affected, what you're going to do or whatever. So, but I'll second.
Any further discussion? Commissioner Walker.
I'm at this time, I'm not going to support it. I don't want to, without significant requests from the public to include 1,300 more parcels into this taxation district. I guess I'm not seeing a need. So at this time, I choose not to support it.
But we're really not voting on it right now. This is just to get something started, and whatever ends up, then we can all either vote no or we all can vote yes or whatever. This is just asking them to go ahead and see what they come up with, right?
Exactly.
Okay, any further discussion?
I noticed the county administrator, I'd like to hear from him, he's not recommending approval or denial, I'd like to know.
Mr. Chair, Madam Commissioners, it comes from a committee of the county board. I don't feel it's my purview to weigh in unless I have something unique and additional to add, so therefore I just noted it as other.
Any further?
Yeah, I'm curious, the boundary looks like, let me find a map here, I know there were several.
There you go.
Okay. The boundary is just shy of, well, not just shy, but almost nearing county, or Highway 95. And that seems just really extreme, in terms of expansion. Can anybody speak to why we would go that far northeast?
The current lit boundary does extend that far with the darker color on your map, and so that's actually really close to the current boundary. There wouldn't be much change there. The majority of change would be on that kind of a peninsula on the south end that would be added. There's also a peninsula of properties on the south end that would be removed because they're outside of the watershed area. So, and then you see the larger area where we required a number of the drainage easements up in the northwest area is a large expansion too.
So that would be North Chisago Lakes. Along 19, Flint Township, North Chisago Lakes.
Maybe to get at your question, this map was not established by the Lake Improvement District. It was established by the DNR. There's people at the DNR that's their job is to establish watershed boundaries. And so that's the watershed boundary of the Lake Improvement District, or the Chisago chain of lakes.
Any other questions? Seeing none, all those in favor say aye.
Aye.
Aye. Those opposed?
Aye.
Okay. 4-1.
Mr. Chair, before you move on, did we get a motion to receive the lit annual report?
Okay. Thank you.
I'll make the motion to now approve the record report, annual report, and well, we voted on this one, so item 12 and 13.
There's 13.
We already did 12.
We did 12.
Well, we didn't do 12, we referred, I think, didn't we?
No, I didn't.
Okay, item 13.
Need a motion on that,
Okay,
Commissioner.
I'll make the motion.
Commissioner Robinson.
Then can I have it?
Thanks. I'd like to do it, we're receiving the report.
Right.
Directly will show.
Okay, Commissioner Marshall, second. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Those opposed? Carries.
Thank you.
Thank you.
Thank you, Jerry. Tab number 15 is my next agenda item. This is an item that the board had referred to the Planning Commission to discuss Planning Commission membership and makeup. So on March 5th, the Planning Commission did review the section in our zoning ordinance that pertains to their membership. It's section 803 entitled Functions of the Planning Commission. I've identified and attached a number of items, but suffice it to say the Planning Commission had a good discussion. They did recommend a change to section 803 of the zoning ordinance, which would do a couple of things. I'll highlight those for you. In the request for board action is the actual motion and the recommendation. The recommendation, in essence, would be to remove the 2 at-large appointments to the Planning Commission and replace those 2 at-large positions with an additional appointment to District 2 and District 5. There were also a couple of friendly amendments related to residency of a municipality and attendance-related matters with the Planning Commission. You'll see in the request for board action, we've done an initial staff assessment related to some changing population variables and some analysis of the incorporated versus unincorporated areas that have been identified on the back page of the RDA. some additional, again, preliminary analysis notations about what such a change might mean. What I'm asking and bringing forward to you on behalf of the Planning Commission tonight is a motion to proceed with public notice, public hearing, and a full review of the suggested and recommended ordinance change, amending section 803 of the zoning ordinance to change the membership representation of the Planning Commission.
Need a motion to put it on the calendar?
Yeah, I'll make the motion.
Commissioner Robertson.
I'll second it.
Commissioner McMahon, second.
Can we discuss this now, right now?
Absolutely.
Okay. I have no problem with the 5 districts each having 1 member. And I know some of the people on the Plan Commission want to kick the city people out, and I don't think that's right. I think we should be able to have members from the city or the townships or whatever. I don't think we should not let city members on. I think everybody should have that chance for the 5, because some of the best, since I've been on here, some of the best Plan Commission members actually came from the cities. Like Frank's in Wyoming City, but like Kurt Klug is real good, he's City of Lindstrom, so I think we shouldn't limit the Planning Commission on that part. If you live in the cities, you can't be on there. I don't think that's right. I do think that the 2 at-large positions, one of them should be in District 2 and one of them in 5, but just the makeup of the populations that the Planning Commission handle. But I don't agree with the part by not allowing. This way, everybody in the county has a chance to be put on there. Otherwise, the guys that were voting or wanted that were the ones living in the country and wanted to kick the city guys off. So I don't think that's right.
Commissioner Sue.
Yes, Mr. Chairman, Kurt, I'm wondering if there's been any analysis at all about the projects. Rather than the boundaries of Commissioner District, what is the volume of work that comes from each area? And what is it that the Commission is actually working to accomplish? Can you answer?
Given the recent offering of this recommendation from the Planning Commission, it's a good question, and I think if we were to move forward with an amendment, we would do some analysis and pull that together. But we don't have a count per se. I could give you a general guess that a lot of what we've been doing in my time here has been a little more rural conditional use permit activity for rural recreation. We have one item coming up for a distillery. We've seen, without looking at the exact numbers, we've seen a little more of that kind of application, land use application, and variances tend to be closer in on the lakes, maybe in this, but they're still in the township areas.
I guess it's my own feeling that we're analyzing this from the wrong perspective, and it should be focused around where the work is from. And until we look at that, I don't know that I'd vote for any particular district to have more members. I think we need to focus on where is the work coming from. Otherwise, we're fine with what we have. Maybe more representation would mean that we have an 11-member commission. I know that's legally allowed. But I'd like to know the answer about where's the work coming from.
With the discussion, Mr. Chair.
I appreciate Commissioner Robinson's concern on this, and I appreciate his comments. I lived in a township that had taken on the same powers that Lynn Township has done. I lived in a township that has taken on the same powers that Lynn Township has done, and I can assure the county board that residents of the township that I lived in still felt the hand of the county governments on it. They determine the outside limits of what can be done, and they still need that representation. I appreciate so much Commissioner Robinson's comments on it. I would just respectfully probably not be able to do it because I feel that at least in my mind, maybe not legally, but at least I just feel like it runs afoul of the 14th Amendment to the Constitution, which provides for equal representation under the law. And it's not based upon whether you live here or there, but it's based upon the fact you're a Chisago County resident. And even though I'm very sensitive to his concern and I appreciate his passion, from the perspective of a resident who never chose to live in the city but was constantly annexed into it, my county rises and falls on a total picture, and I know that for myself I would feel just as committed to make sure that the zoning looks good, because the whole county itself does. But that doesn't take away the concern that Commissioner Robinson has, and as an informal nature, I've always felt that it made sense to informally appoint someone from the unincorporated areas that have that large thing and large seats, and I would certainly appreciate so much your comments, Commissioner Robinson, that I would informally continue to push for that as well and support that. But I have a problem with it doing it as part of statute for the reasons I mentioned.
Commissioner McMahon.
Mr. Chairman, I see the chairman of the Planning Commission in the audience, and maybe we should refer this, after you heard the comments, maybe we should refer it back to the Planning Commission. You go to the Planning Commission, talk about the issues that we brought up here tonight, and have them bring it back to us in some manner. It may come back the same way, but it may not. So I think what I'd like to do is, if this is the right time to do it, I'd like to refer this back to the Planning Commission, and you, Kurt, go to the commission and say, this is our position.
These are some of the ideas.
And some other ideas, and you said you had some more information about what cities or townships use the planning commission as their planning commission, I guess is the best way to say it. So I'd like to refer it back.
Wasn't that kind of what the motion, the first motion was to send it to those guys?
Send it back for further review.
No, the first motion was to approve.
To
Them
proceed
looking
with
at it.
a public notice and a public hearing,
Yeah.
which, should you proceed with a public hearing and public notice, you would be asking us to draft the ordinance change, and so.
Yeah, but are we ready to ask that? That's why I'm saying refer it back to the planning commission. With the,
Mr. Chair, members of the commission, I think to clarify, Commissioner Robinson's comment was that several meetings ago it was referred to the planning commission. Now you have their first look. If Commissioner McMahon would like the planning commission to take another look, procedurally what you should do, Commissioner McMahon, is withdraw your seconding.
I made the second.
Well, you made the second?
He made the motion.
You made the motion. So Commissioner McMahon.
You sure?
Yeah. So Commissioner McMahon should withdraw your second, and then you'll see if there's a second for further discussion. If there's not, then you can make an alternative motion to remand it back to the planning commission.
okay, I'll withdraw my
Second.
One other
second
comment
or my
before you do
motion.
that. The plan that's on there right now, every unincorporated township has 2 representatives right now.
I saw, yes, I know that.
Okay. Okay, you're withdrawing?
I'm withdrawing.
Okay. And you're making a motion to refer back to?
No, first you should ask if there's a second to Commissioner
I
Robinson.
can't say,
No,
I'm out of the picture.
You're good, you're good.
Your motion's still there unless you withdraw. Is there a second to Robinson's motion? Is there a second to Robinson's motion? Is there a second? No second, okay, so it dies for lack of a second. Now you can proceed to refer it back to the planning commission for further review.
Okay, I'm gonna refer this back to the planning commission with the comments that we made from this board to the planning commission, and with the additional information you have in terms of, I guess you call it usage of the planning commission.
Okay. Motion by Commissioner McMahon, need a second.
Second.
Commissioner Wonka, second, okay. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Those opposed, carries unanimously. Thank you.
We'll move to tab number 16 on the agenda. This is a planning commission conditional use permit request for board action. I'll summarize for you that the County Board of Commissioners first approved this original conditional use permit back in June of 2014. Mr. Jerome Dill is requesting an amendment to his existing conditional use permit for a micro distillery. There's been some statute changes, and his amendment would allow him to have limited additional sales of his products, which allows micro distilleries to have essentially a cocktail room in order to offer expanded tasting of the product. What it does not do is continue it does not allow bottle sales or retail sales of his product on site. It's simply an enhanced tasting process. The Planning Commission did review this request on March 5th. They did recommend approval. Because there are no physical changes to the property, no additional buildings or other exterior changes, they did not recommend any additional conditions. With an existing conditional use permit, the original conditions remain in effect. So they've recommended approval of this amended conditional use permit for Mr. Jerome Dill.
Okay.
I'll move approval.
Commissioner McMahon makes a motion to approve, Commissioner Robbins second,
Don't matter.
Commissioner Walker second. Any further discussion?
I'm questioning how this is any different than Winehaven. Or is it very similar?
I'm not real familiar with the Winehaven site or operation. This site specifically is on an old homestead site, produces the product on site, and wholesale sales of the product would eventually occur. I'm not real sure if I can compare and contrast the two.
I think they have a tasting room and for their wine sales. You like it, you buy it.
Yeah. And I do know at this distillery you can't buy it at the site.
And
Commissioner McMahon?
I think it's flavoring, isn't it?
Yes.
Adding strawberry to whatever, I say strawberry, I mean strawberry, whatever flavoring he's adding to
His product.
the product that he's producing. But the law says he can do that now, and when he applied, you couldn't do that, so we're just following the state law, I guess.
The micro distillery trend has continued, and the state statutes are tracking right along with them. So.
I think it's tasted out in the parking lot.
Well, there's a product out there now that is going through testing that is powdered whiskey.
Alcohol.
Alcohol. Alcohol.
Powdered alcohol.
Okay, any further discussion? Seeing none, all those in favor say aye.
Aye.
Those opposed?
Okay, tab number 17, presenting from our Parks Division here in the Environmental Services Department, is a cooperative agreement with the state of Minnesota and Chisago County. It relates to the East End Swedish Immigrant Trail project. In summary and covered in detail in the request for board action, we have drafted a cooperative agreement with the state of Minnesota to allow access to the very east end of the Swedish Immigrant Trail construction site for purposes of construction of the trail and construction of a bridge that crosses a ravine through there. The current agreement does allow for the possibility of temporary trail work as well as just the construction access, and we are recommending to move forward with that cooperative agreement. I did note a number of other things in the RBA and can cover details if you wish.
Okay. I'm gonna make the motion to approve the amended motion that Bruce is gonna state.
Okay, I'll take over then while you do that. There's a motion by Commissioner Green to approve of this. There a second?
I'll second.
Second by Commissioner McMahon. Any more discussion on this?
What's the motion? Bruce, do you have a motion?
He made the motion.
The motion is to
Approve it.
Mr. Chair.
Okay, go ahead.
Members of the commission, at the request of Commissioner Green, I did take a look at the agreement, and the request was to prepare an amended motion that would call for seeking a construction access agreement first, and not have any direction within the first motion regarding the temporary trail access, but instead to work with the DNR on that for subsequent review by the county board. And so, as I understand the motion, it would be to approve the resolution as it states. However, it would be germane only to a temporary construction access agreement.
That's myself, and make it very clear that anything that says temporary trail, this is a construction purposes only, general agreement is done. And, you know, this is a great step forward on that trail that's been taking us 23 years to build. So, if we build this trail and we come to the end, we don't get the approval. I guess I'm talking about the other motion. Let's approve this one first.
Any more discussion on this? Commissioner Moskowitz?
Thank you, Mr. Chair. I just want to make it clear as well that, that this is simply not stating that issue at all at this point.
It's not.
In speaking with staff about it, it seems like this is not going to foreclose various options. There are certain problems with the trail being along the county road there. There's not enough space, so there's a lot of due diligence that needs to be done as well. And I know that this is a very important amenity, so we want to move forward and with, I guess, the ultimate goal that there not be a temporary anything, but that we move to the east whatever the plan would be. I think that's something that I just want to make that clear. Thank you, Mr. Chair.
Commissioner Walker?
I have, this is tab 17.
Yes.
I have different language in my board packet.
That's why he read the new motion.
It's a motion.
Yeah, I thought it was 17 what we were voting on too, that's why I thought that's what Rick's motion was.
That's what it is.
Okay.
It's the motion that Bruce
Yeah,
made.
if you go to your tab 17, I'm assuming unless your book is back, Commissioner, first you have the RBA.
Yeah, I have that.
Okay, and then the second page should be the map.
Yep.
Okay, and then the third page is the resolution. I hope, otherwise Chase is gonna be embarrassed to.
Have that.
Okay, the resolution itself is fine because the resolution does not reference a temporary trail access agreement. If you go to the next page, you get into what is a draft cooperative agreement. And what I've done, just for the board's sake, and we did this by general motion, but I can go over specifically, is I went through this and I removed any reference to the temporary trail access from this cooperative agreement. So with the board's action tonight, we would go to the DNR and seek a construction agreement. And then we will work with them on trail access issues, but anything that would ever come back would come back to the board as a separate action. So for example, if you go to the bottom of page 105.
I'm sorry, Mr. Chair, I think because I had the planning book here, I never got this other updated book.
Okay, it's not updated.
I'm missing that one page.
Okay, if you go to page 7, or tab 17.
That's 17, okay?
Okay, the first page is the board RBA.
Okay?
Second page, if you flip it, I believe is it a map?
Yes.
Okay, the third page is the resolution.
Okay?
Okay, the fourth page, if you flip it, is the actual cooperative agreement.
So that's all I'm supposed to have?
Correct. And if you, as an example, if you go to the fourth page, and on the bottom it's listed page 1 of 5. If you go to the bottom of that page, you'll see 1B, for instance, says the state shall be allowed to review and approve the preliminary and final plans for the temporary construction access. And then we will line out and temporary trail connection. So it'll just be temporary construction access as proposed by the county. And then again, it says the proposed trail connection shall meet ADA requirements. That would not be in there as well. So that's an example. We would go through the agreement, remove the temporary trail access issues, related discussion with DNR. All you'll be approving tonight is a cooperative agreement for the construction of the trail itself. And I've got the full line in line out if the board would like to review it.
Any more discussion?
I'm just questioning why all commissioners weren't given this different language.
because it was worked on at about 6 o'clock tonight at the request of the chair, so I didn't have time to copy it for you.
All in favor?
Aye.
Aye.
Opposed? Motion carried.
Tab number 18 in your packet is similar but yet slightly different action item. We are asking for your approval to submit to the Minnesota DNR an easement application to secure a 20-foot by 488-foot roughly easement for the along County Road 37. We've identified that easement purpose in the RBA as to preserve or reserve the possibility of routing of trail along County Road 37 to Taylor's Falls City Hall. We've identified for you in the request for board action how we've come to the desire to pursue that additional easement as we wait for additional state trail work within the state park. And so we're asking for your recommendation to proceed with that easement application to the state.
We got a motion for this?
Yeah, that's a motion to approve the submittal of the state easement application and accompanying resolution authorizing procurement of the land easement in Minnesota's Department of Natural Resources, period. The last part for construction of the Immigrant Trail East project is eliminated. That's not a part of the motion.
Okay, is there a second?
I'll second that.
Second by Commissioner McMahon. My understanding of bike path only has to be a little wider than one bike type. Okay, any more discussion? Bruce?
Mr. Chair, members of the commission, if you vote on the amended motion, if you would also allow, because we didn't rewrite the resolution, if you would allow us authority to rewrite the resolution to follow the motion, that would be great.
That okay with whoever made the motion? Okay, any more discussion on this? All in favor?
Aye.
Opposed? Motion carried. Should I keep going? We can get done faster. You
Yeah.
want to go ahead.
That's all I have for you tonight. Thank you.
Okay, thank you very much.
Thank you, Mr. Chair, members of the commission. We have item number 19 next, which is a discussion directed by the county board from the county attorney, and also joining her tonight is the county sheriff. I don't know if you want to go up with Tina. And we will defer to the county attorney.
Good evening. When the county board last convened on March 4th, I was given the directive to look into and prepare some information about residency restrictions or the options for ordinance to regulate where sex offenders can reside in Chisago County. I did prepare for you just some background information. One of the pieces was a memorandum that more clearly clarifies the types of persons or the persons that we're dealing with. In Minnesota, we refer to our sex offenders as predatory offenders, and the reason for that is that the state statute includes not just those who have committed sex offenses per se, but also kidnapping and several other offenses such as indecent exposure, those types of things. So in Minnesota, we refer to them as predatory offenders. And I would say that it's important to note that not all of our predatory offenders or sex offenders go to prison or do prison time. We have a fairly robust sentencing guideline statute that determines maximum sentences or guideline sentences for these offenders. And more often than not, those guidelines that are set by the Sentencing Guidelines Commission are followed. So when we talk about folks that we want to control or regulate as to where they can live or where they're going to reside, we want to make sure that we're talking about predatory offenders, and typically the ones that upon which we have the most supervision and ability to determine where they live are going to be those predatory offenders who have been committed to the Department of Corrections and served time in a prison. And I say that because there's two laws that interact here. The Predatory Offender Registration Act, which gathers all the information about those who have committed these offenses, whether they go to prison or not. Their residency, their employment, and their car, all and the car that they drive, is data that is all accumulated and maintained through the Department of Public Safety and enforcement of where they live and whether or not that is updated and kept up to date falls on the local sheriffs, and that's why Sheriff Duncan is here. His department is primarily responsible for that function in Chisago County. Once a predatory offender who has done time in prison is set to be released from prison, they then are subject to an end of confinement review. It's that point in time where a panel of professionals, law enforcement, psychologists, and other professionals who work with the individual in prison will review their background information and assign a risk level. This process is based on empirical data that is determined by the Department of Corrections to have some impact, some weight or value to determine whether or not these individuals are less likely to reoffend, moderately likely to reoffend, or highly likely to reoffend. So the individual that had brought this subject to our attention was a level 3 predatory offender who was released from prison and was intended to live in Chisago County upon his release. So I provided that background information for you, and also some literature that addresses whether or not laws that govern where offenders will reside have an impact on public safety or have an impact on whether or not they are likely to reoffend. Interestingly enough, one of the leading cases that helps inform this discussion comes out of the state of Iowa. It's an 8th Circuit Federal Court of Appeals case that determined that statute, and it was a statute, not a local ordinance or community that passed the law, but a state statute that prohibited offenders from residing within 2,000 feet of a school or a child care facility, did not violate a number of considerations such as the due process clause of the 14th Amendment. It wasn't a retroactive criminal punishment. It didn't interfere with the offender's right to travel, or it didn't interfere with his right against self-determination. That is one of the leading cases in the country. It was passed in 2005, and it was oftentimes cited in other cases. But on the flip side of that, 2 days before we met last time, so back on March 2nd, 2015, there was a case that was considered and ruled upon by the California Supreme Court. And that case, it was a San Diego County ordinance that was intended to apply to all registered sex offenders and was to dictate where they could live within the county. They don't have the specifics where they prohibitions, but it was basically a blanket enforcement against all registered sex offenders and where they could reside. And it limited their residency such that they were required, it inhibited their ability to find housing, inhibited their ability to find medical treatment, drug and alcohol treatment, and other services that might help them to maintain their stability in the community. So those are 2 statutes where one was limited to certain predatory offenders, a certain number of feet from schools or child care facilities. In California, there was a blanket restriction on all registered sex offenders and limited them from residing in certain places within the county. Those are 2 drastically different types of ordinances. I'm not here to advocate for one or the other. I can say that the research that I did, there are approximately 30 states and thousands of municipalities and local rules of government that have passed these laws. There are dozens and dozens of cases that litigate various issues of constitutionality and other areas of legality regarding these ordinances. But they are very controversial, and there's 2 things that I would say that if the board still has an interest in addressing this, I would say that it does require a lot of consideration, and the things that we would be required to, or I would suggest that we look at is who are we looking to regulate? What offenders are we looking to govern by an ordinance of this nature? Some of our local communities have, in their ordinances, have addressed people, offenders who offended against children 16 years old or younger, not just the level 3 predatory offenders who we consider to be a higher risk level to reoffend. And secondly, another factor that is important to consider is what would you regulate? those are areas that will be common. When you think about how that would play out and, be implemented in Chisago County and, other than within the municipalities, you, there are a limited number of areas, but it would not be a wholehearted blanket or blanket prohibition of these offenders within Chisago County. So there's a lot of considerations that the board would want to consider if they wanted to go this route, but I really want to caution that whatever is implemented or considered, it has to be narrowly tailored to address a compelling governmental interest. And by that, I mean, there's, in the 15 or 20 years since these, laws, the Predatory Offender Registration Law and, Community Notification Act have been in place, there's been a lot of research done on the impact of these laws and whether or not it, one, keeps children safe, and two, has any impact on the recidivism or reoffending of these individuals. And there's not a great deal of research, but I did provide that to you in that there is not a lot of empirical data that says these types of laws have an impact. So I want you to very carefully consider that and determine whether or not it's sound public policy to implement a rule or ordinance or restriction that has not been proven to have a significant impact on what we're trying to regulate and control. I know the sheriff is very passionate about this. I was just chatting with one of his staff members prior to today's meeting, and he said, I'd be happy to spend that evening at the board meeting tonight, so here he is. Invite him to chime in.
And I said most of this at the notification meeting, we talked about in Chisago County, most of our sex offenders, the offenses are basically people, are either partners or family, or of course, most of them are not, except for Kathy Christie, one of the sex offenders was not a family member. And I said this at the meeting, laws basically state that